Okay, let's jump right into this explainer. Today, we're going to put on our human rights legal expert hats and really examine the intense David versus Goliath battles over land rights, forced displacement, and corporate accountability in India. It's an absolutely fascinating area of law, mostly because it's the exact flashpoint where everyday human livelihoods collide head-on with massive industrial ambitions. We're going to unpack the whole evolution of displacement rights in India, looking closely at how communities have organized and responded to state and corporate land grabs.
So here's our roadmap for today. We'll start with the roots of resistance, move into the shifting legal standards, and then dive deep into the Pasco mega project. After that, we'll look at the grassroots movement that fought it, their landmark victory at the National Green Tribunal, and finally, what this all means for the future of displacement. All right, Section 1, the roots of resistance, looking at colonial laws and the baseline of displacement. Now, to understand where we are, we have to look at where we started. For well over a century, India's land acquisition laws were deeply rooted in the 1824 Bengal Regulation and 1894 Colonial Act. And let me tell you, these laws heavily favored state power. They were literally designed to acquire land for this incredibly broad, vague idea of public purpose, giving the government the ultimate authority to displace vulnerable communities at a very low cost. It actually wasn't until 1984 that we even saw amendments for rehabilitation provisions appear. And it took all the way until 2013, think about that, for the Colonial Act to finally be replaced by the LAR Act. But long before that 2013 legal shift happened on paper, the real foundation for modern resistance was being laid out on the ground. The Narmada Bachao Andolan, a massive historic grassroots movement led by environmental activist Meta Patkar, fundamentally challenged these draconian colonial norms. When hundreds of thousands of people faced displacement by the Sardar Sarovar Dam, this movement stood up. They demanded proper, dignified rehabilitation and really shined a spotlight on the environmental destruction, essentially setting the modern precedent for displacement rights. It was a total game changer. Moving right along to Section 2, shifting legal standards, forcing an evolution. Look at the sheer contrast between two of the most pivotal events in this space, the Singer case and the Pasco case. On one hand, you had the Tata Motors factory in West Bengal needing over 1,000 acres. On the other, the gargantuan South Korean Pasco steel plant in Odisha, demanding over 4,000 acres. Both of these became absolute stress tests for India's land acquisition policies. They basically forced the courts to figure out how to balance rapid, hyperscale industrialization with the protection of local agriculture and traditional livelihoods. In the Singer case, the West Bengal government had forcefully acquired farmland for a private corporation, which immediately sparked massive farmer protests over inadequate compensation, while the Supreme Court's 2016 ruling was a total watershed moment. The court stepped in and declared the state's acquisition outright illegal, ordering the land to be returned to the farmers. This was a seismic shift. It redefined public purpose, basically establishing that the state absolutely cannot just bulldoze and acquire land strictly for private corporate use at the expense of local communities. Which brings us to Section 3, the Pasco mega project, the ultimate stress test. Okay, we really need to pause and grasp the unprecedented scale of the Pasco project. We're talking about a $12 billion foreign direct investment, the single largest in India at the time. Their plan? To pump out 12 million tons of steel every single year. But to pull that off, they needed over 4,000 acres of incredibly fertile coastal land. And here's the catch. That land already supported a thriving, highly profitable local economy based on beetle vine cultivation and fishing. It sustained roughly 20,000 people. So the stage was set. Massive global capital standing on one side and 20,000 rural livelihoods on the exact opposite side. So what happens next? Section 4, grassroots against the Goliath, the anti-Pasco movement. When we look at the specific strategies of the resistance, it's pretty incredible. The anti-Pasco movement organized in 2005 under the PPSS, and they deploy this highly sophisticated two-pronged strategy. Out on the ground, it was intense. Women and children literally formed human barricades to physically stop government officials from entering their villages. They aggressively highlighted the environmental devastation, pointing out that some 300,000 trees were going to be felled. And concurrently, while defying prohibitory orders with peaceful sit-ins, they were mounting fierce legal challenges in the courts. And a crucial piece of that legal puzzle was the Forest Rights Act of 2006.
The movement brilliantly utilized the Gram Sabhas, the local village councils, to legally pass binding resolutions rejecting the megaproject. They strategically wielded this brand new law against the state's traditional methods of land acquisition. They were essentially proving that community consent cannot and will not just be bypassed by top-down government mandates anymore.
Let's dive into Section 5, the NGT Landmark Victory, Exposing the Flaws. This brings us to a really fascinating turning point in legal history. You have to ask yourself, on what exact legal grounds did the National Green Tribunal, the NGT, actually suspend POSCO's environmental clearance? How on earth did a local grassroots movement legally halt the largest foreign direct investment in the country?
Well, the smoking gun was in the Environmental Impact Assessment, or EIA. When the NGT reviewed the mandatory EIA, they found a massive, fundamental flaw. POSCO's environmental clearance was based on an assessment for producing just 4 million tons of steel per annum. But remember, the project's land and water allocations were already being laid out for the full 12 million tons. The tribunal looked at this and declared the clearance completely arbitrary and illegal because it drastically and deliberately underrepresented the project's true scale and its devastating impact on the local coastal environment.
This really powerful quote from appellant Prafula Sementara perfectly captures the mood of the movement back then. He said, "People will not depend on any judicial process, but recent verdict of the NGT shows that people were right in their opposition, and they will continue their struggle." It's just a brilliant encapsulation of the intersection between grassroots action and formal legal validation. It completely emphasizes why deep, meaningful public consultation isn't just a box to check. It remains absolutely vital for environmental justice. Finally, let's wrap things up with Section 6, the future of displacement and the legacy of resistance.
So, the immediate aftermath? POSCO officially threw in the towel and withdrew from the project in March 2017, entirely due to these relentless local and legal hurdles. But, plot twist, the struggle didn't actually end. The 2,700 acres of land that the state had already acquired, it was never returned to the farmers. Instead, it was transferred into a state land bank and then quietly allocated to another giant company, JSW Steel, in 2018. Predictably, this triggered a brand new anti-Jindal resistance movement. It just goes to show that the fight for fair compensation, transparency, and genuine land rights under the 2013 LAR Act is very much an ongoing, everyday reality. Which leaves us with this final, incredibly critical takeaway. As these massive corporate mega projects continue to expand all over the globe, are our legal systems going to evolve fast enough to ensure that meaningful public consultation actually protects the most vulnerable communities standing in their path? The whole POSCO saga perfectly demonstrates the extreme friction between rapid industrialization and fundamental human rights. How our modern laws choose to balance those competing interests? Well, that's going to determine the entire future of displacement globally. Thank you so much for joining me on this explainer. Keep asking those tough questions and